Hey, Scott from aristocob.com here.
And Seth from theshrinkingpastor.com.
Together, the three of us, we are Markwood Men's Breakfast Club. Welcome back once again. Good to see you.
Good to see you too.
Morning, boy.
And them as well. Morning.
So, interesting topic of discussion today. Did you see that article about the Supreme Court and the toner refills?
I believe that I did. Because I believe I sent that to you.
That may have been why I saw it.
Yeah. The Supreme Court is hearing a case right now between an end user and a ink printer company. Lexor, I think, might be the one. It's not HP, it's not the other. Tell them more about it while I look it up.
So it's a company that makes printers, and part of their business model, of course, is to sell you cartridges of toner and ink or whatever it is that your printer uses. Well, Lexmark. Some enterprising folks started a business where they take those used toners and they drain them and they refill them and then resell them. And Lexmark threatened them and told them to cease and desist because they have a patent on that printer cartridge. And so for them to sell that product is in fact selling and manufacturing a product that competes against them.
Right. So really the issue comes down to what Lexmark is calling shrink wrap licensing, where they have surrounded the printer and their toner cartridge in shrink wrap, and on that shrink wrap is a message that says, by opening this, you agree to yada yada yada. And what you agree to is that you will not reuse or refill this toner cartridge. This is a one-time use, and by opening, you agree and opt into this contract. A lot like end-user agreements for any website or many services that you use.
Well, and if you go back just a few years, anytime we bought software, right, they always had that little hologram seal on it, and if you cut that. The first time I was introduced to this was probably 20 years ago, and it was a company called Stotts, S-T-O-T-S, and this was a company that made, and maybe they still do, a little plastic device that is a jig that you use to make your own templates for making dovetails. And when you open the box, it had shrink wrapped inside of that, the little plastic jig, and it said, "You did not purchase this. We're licensing it to you. And if you open this, you are agreeing to the following." And among those things, and they also went on to explain on their website in much greater detail that the purpose of this jig is basically to clone itself. So with this jig, you could make this jig. And so they're giving you the rights to use the jig for its intended purposes, which is your woodworking, but not to make jigs that you can then in turn sell.
That's interesting.
Yeah, so it would be like a company selling you a machine that can make itself, like the 3D printers and CNC machines, but with the explicit instructions that you're agreeing to that you will not replicate this machine itself.
Right.
Kind of weird, and I don't know if that ever was tested in court. This, what's fascinating, is all the way at the Supreme Court. I guess a number of people over the years have just given in. They said, okay, yeah, we're not going to refill your cartridges. But this company has said, no, we believe that you're wrong here.
Right.
What is that clause in the patent office about once something is sold to someone, the patent protection ends?
Right. So what's interesting about this is there are two laws that may or may not be applicable. There's trademark law, which is fairly universally applied across country borders. And it seems to have a more defined scope of what it does cover and does not cover. Patent law is different for every country, which is why when you're getting a patent for a product, you have to patent it all over the place, and it becomes really expensive. And then it also is, in situations like this, isn't as clearly defined. So it is the first sale law, which removes a copyright interest in the particular sold item, but patent law does not have that. So, so essentially, if you have an item that has been sold with a copyright, then after the first sale, the copyright no longer holds, essentially. But the same is not true with patent law. And so, what this is going to force the Supreme Court to decide is, does the same law apply to this product? One of the reasons why I find this interesting is because it was recently decided that you don't own your cell phone, and you can't make modifications to it and changes to it because that's against the repair law, which is ridiculous, right? But the argument is this is a piece of technology that is licensed. You're licensing. Technically, you do not own it. The same is true for software. At any point in time, Windows could shut down your machine and remove the operating system, or Mac could remove the operating system from your machine.
Do you remember how a number of years ago so many Kindle users were shocked because they bought a book, Kindle realized, Amazon realized, oh, wait a second, we did not have the right to reproduce this book electronically. So they suddenly removed that from everybody's e-reader. And that shocked people because it's like, wait a second, first off, I own that book. I bought it.
Right.
No, you don't. And secondly, I've already downloaded. Who are you to come onto my device and take that?
Right.
Well, they weren't supposed to sell it to you in the first place. So really, It was a shock. And, I've had this concern over the years with iTunes. Mm-hmm. I have bought so many albums again and again and again because I bought them originally on cassette, then I bought them on vinyl, then I bought them on CD, and even a couple of them I had on 8-track.
Right.
And the fact that I can't tangibly hold a download just rubs me the wrong way. So I still will buy CDs of old stuff. I can buy them on eBay for less than I can buy a single tune on iTunes, have the whole album.
Right.
But I don't own the songs. I can't re-release those and sell those, right? Where this company has basically taken those old songs, if you will, cut them on a new CD, put a new wrapper on them, and is reselling them. And that's what Lexmark is trying to argue has happened. It would almost be like if one of the car companies made a car that was a one-time use, comes preloaded with gasoline, you drive it for 10 years, and then it's out of gas, and you trade it in. And if somebody figured out how to drill a hole into the side and add more, dilithium crystals or something to it to make it continue to run, it kind of breaks into their whole business model. So
yeah. Another, to your point, Netflix at the beginning of April has just removed a lot of shows from their catalog. A lot of Fox shows. So Buffy the Vampire Slayer, namely Firefly is one. And so these are things that I've, come to assume I will have available to me, which is why I have stopped bothering to purchase content digitally or a hard copy. And it's now just going to be gone. It's gone. I can't access these shows that I've...
Well, they did that with the whole collection of Sony movies just a few years ago. Because, part of the reason why I agreed to a monthly subscription was the fact that, all these great movies are on Netflix. Man, Netflix has got nothing now, right? They've got, a bunch of repeats of TV shows. It used to be a bunch of movies.
Yep.
So, anyway... I'm curious what's going to happen with this, and I think part of why we thought this would be a good topic to talk about was we'd like to get your opinion on this. Have you had any experience with this in your run-ins with the law? And what do you think? How do you weigh in on this? Should these folks be allowed to take Lexmark's cast-offs and recycle them and then sell them for use in Lexmark machines?
Yeah, if the Supreme Court upholds and says that is against the law, then what does that say for things like eBay or Etsy, where things are being upcycled, being repurposed? Does the original patent holder have a claim to this upcycled product? Can they put a stop to you selling something if that's your business?
Let's go back to the CDs that I'm buying. For all I know, the owner of that CD made copies and then is in turn selling that CD. They're not supposed to do that. Right, they're supposed to destroy any copies they make. Back in the day, years ago, with vinyl, we used to have a big library of music in our church youth group, and we made a cassette copy of all the vinyl, and we would loan out to the kids a single copy because that was legal. And then if that copy got worn out or lost, destroyed, we could then make another copy. But following the law, we weren't supposed to be circulating both the album and the cassette.
Right.
You can use either the original or the copy. And I don't think a lot of folks today really honor those copyright laws.
No. I mean, they're so easy to get around it. I am close to pulling the trigger on purchasing a 3D printer, which I'll hear all about when that happens.
Wait,
and
you're gonna purchase one?
I'm getting one. Whatever.
I thought there was some discussion about this.
If you want to pay half, that's fine, but it's staying at my house, so.
Well, yeah, you can stink up your house with that thing. It's true.
Anyway, I've been on some forums about it, and there was some discussion about someone who is taking these designs and selling printed versions of them on eBay. And is that legal? Is that how does that stand? It is something that the design was not marked for commercial use. So technically, from the copyright standpoint, the owner has claim on that. But a lot of people, a surprising number of people, fall onto the too bad, so sad position of, if you put it out there for the internet, if it wasn't valuable enough for you yourself to hold on to that and sell it yourself, and if you choose to put it out into the internet, while yes, technically, legally, you do have that standing, you don't.
You get what you pay for.
That's right.
I mentioned that dovetail jig.
Yeah.
I went and pulled up the instructions for this thing, which I believe the company has since passed it on to someone else because their website no longer exists. But I found the owner's manual that included the license agreement, and it begins with a card that you're supposed to fill out and send them, and that says honor statement.
It says, I am honorable.
Basically what it says. Yeah.
Wow, it's saying, we'll send you a replacement if you lose it, but because I'm honorable, if I ever find the replacement, I'll send it back to you.
Yeah.
Say I won't keep two of them.
What's weird is, I imagine that this would not hold up in court because as I'm reading some of this licensing agreement, part of the way through here, as it's talking about how the life of this, and it's going to last, if it lasts for 5 years, the purchaser will hold them harmless. Well, wait a second. Earlier you were telling me I'm not a purchaser.
Right.
Well, I guess I purchased a license.
Yeah, the laws like this, or contracts like this, end-user agreements like this. Uber has one where Uber says in their end-user license that you will not sue Uber. By using Uber, you agree that you will not sue Uber, period.
Super, basically.
Right. And that's in there not to prevent people from, not because they think they'll win in court, but because they know that most people can't afford to fight that court battle anyway.
Are you agreeing to arbitration? Do you know?
It just says that you will not. You basically have no legal recourse.
A lot of those agreements basically tell you that you're agreeing to arbitration.
The arbitrator is decided by the company.
Correct.
Right.
Yeah. So that's good luck. Good luck for you. So it's got 2 people from Uber and 2 people from Lyft on it to keep each other honest. It's fascinating. I mean, this whole thing, it can go on and on. I mean, again, do I have the right to take someone's book that is currently covered by copyright law and to record me reading it on YouTube?
No.
I mean, I'm not copying it.
Right.
But I'm potentially harming the author in that respect. All of this comes down to civility and why we agree as a society to do certain things and not do certain things. And society falls into anarchy when we all say, screw the rules, you do what you want to do, I'm going to do what I want to do. And that is, I'm going to take the fruits of your labor. And none of us would want to have someone taking advantage of what we've produced.
Right.
We should honor the efforts that go into what everybody else is producing.
Yep.
So, hey, but that's just my opinion. What do you think? Thanks for joining us today. Make it a great week, and tell us what you think.
See you later.